A month after you file, you have what we may call a court date, but oddly enough, bankruptcy judges are prohibited by law from attending the 341 meeting or creditor meeting, as it's also called. So that is presided over by a trustee, just some of the acorns falling, by a trustee, not a judge. In Detroit, the hearings are scheduled for Chapter 7s every half hour, on the half hour, and they're doing 7, 8 of these at a time. So that hearing is about maybe 5, 6 weeks after your case is actually filed with the court, officially filed, given a case number, and at the hearing nothing is decided. There is no one there with any authority to decide anything, but every person or company, corporations can also file Chapter 7. Must appear at the hearing to be available to answer questions of creditors. They usually don't show up. We'll get into that in a later discussion on the 341 hearings. Now, at the 341 hearing, then there are deadlines after that. There are 60 days after that for the creditors to object if they think you should still pay the debt for some reason in the bankruptcy code, that your debt should be accepted from a discharge. So after that 60 days is up, you're eligible for the discharge. The trustee actually has 30 days after that hearing to object to the exemptions you have scheduled for your property to be claimed as exempt. That'll be the topic of another video discussion as well. So Chapter 7, you have to disclose all of the information, all of your creditors, even the ones you want to pay, even the water bill if it's behind, even the credit union, though they take that payment out of your check and you don't think it's a debt, even the debt that you co-signed for somebody and they're still paying it and you don't pay it. These are all debts. Even the claim someone has against you from a car accident or something, they didn't sue you yet, but the claim arose at the time the incident happened. All of that has to be disclosed to the court, and then you want to go through the process. Hopefully you never see a bankruptcy judge. The judge is there to resolve disputes. So unless there's an issue that's brought up by the trustee or one of the creditors, there's no actual dispute, and the papers are filed correctly. You have some counseling requirements to meet under the law. You have to do credit counseling before you file. It's a little late for that to be of any use in you handling your creditors, but that has to be done. There's a second financial management portion that must be completed after you file the bankruptcy before you can get a discharge. So you do all those things, and the creditors don't have a reason to object, which we'll talk about in the video blog on discharge. Then you get the discharge, and you don't have to pay the creditors. You have the relief.